and agencies of the Anglican Church have put their own redress schemes into place to provide an appropriate response to survivors of abuse. These schemes have offered pastoral support, counselling and practical assistance, including monetary payments, to those who have been abused. Our submission addresses each of the 23 questions raised in the consultation paper, and we don't intend to cover each of those points, but would like to take this opportunity to expand upon the key principles that have guided our responses. We support the elements of redress as proposed in the consultation paper. A redress scheme should include a direct response by the institution, access to counselling and pastoral care, and monetary payments. The redress schemes already in place in the Anglican Church have a particular emphasis on pastoral engagement with survivors of abuse. We support an holistic model which provides an opportunity for survivors' views to be acknowledged and honoured. It is important that church leaders hear and respond to their stories. In our experience, a survivor often welcomes the opportunity to meet with a church leader to receive an apology, an assurance that the perpetrator has been dealt with and that steps have been put in place to assure them that similar abuse won't happen again. For many, their faith in God and spiritual life has been shattered by their experience, and they are also seeking spiritual guidance and assistance. We have found that this personal connection can be an important part of the healing process. However, we are also aware that some survivors feel unable to engage with the institution at which they were abused, and we understand and respect that. Therefore, we do support the principle that a survivor of abuse should have the right to choose if, how and when they engage with the institution, and most importantly, that participation in any redress process should cause them no further harm or distress. For this reason, we do support the development of an independent alternative to institution-run redress schemes. In our submission, we've not been prescriptive about how such a scheme should be structured. We have suggested an effective model might be an integrated redress scheme that offers choice, allowing survivors to connect with a centralised scheme that is independent of the institution, or allowing them to connect directly with an accredited institution, being one which has demonstrated that it satisfies the criteria set by the centralised scheme. This is only one option. We know there is more work to be done, and we look forward to making a positive contribution in response to the Commission's further deliberations and final recommendations. In our submission, we have chosen to focus on identifying the principles that we believe must underpin any effective redress scheme, whatever its structures, and I'm going to expand upon some of those principles. To start, it must be consistent. It must provide consistent outcomes for survivors, irrespective of which institution is involved or where the abuse occurred. Survivors must be treated in the same manner where their abuse and impact is similar. The severity of abuse and its impact are the principal relevant factors in determining a monetary payment. To ensure consistency, all institutions participating in whatever form of redress scheme is adopted must agree to how the combination of these factors contributes to the calculation of the monetary payment. It must be efficiently managed. It should provide a timely response to survivors and not divert resources from their support into administration. The establishment of an expensive bureaucracy is not a desirable outcome. It must be easy, accessible and easy to navigate. As we've heard, coming to terms with past abuse and speaking openly about it is challenging for survivors, and dealing with institutions is daunting. The survivor must be supported and guided through the process. Personal contact must be empathetic and demonstrate an understanding of the survivor's needs. It must provide the opportunity for a direct personal response by the institution. We have already acknowledged that this is not always sought, but it should always be offered. Institutions should meet with survivors when requested to do so. For the Anglican Church, this is a fundamental aspect of our response to survivors of abuse. A redress scheme must provide counselling and psychological care. Most importantly, this care must be provided by appropriately trained and accredited counsellors. In regard to funding, independent actuarial advice could assist in determining an institution's funding responsibility for ongoing care on a case-by-case basis. A redress scheme must be sustainable and viable. While many institutions are currently responding to abuse that happened decades ago, we should anticipate that reports will continue to come forward. We should be encouraged that much has been put in place to ensure the safety of children over recent years, particularly our work in the Anglican Church. However, as we know, it can take some people more than 25 years to report the abuse that happened to them as a child. Institutions will continue to face redress commitments into the future. If the payments are set too high, these future commitments may not be able to be met, and the ongoing viability of some institutions which currently provide valuable services to the community will be jeopardised. In our submission, we have said that we cannot yet express a view upon what the average and maximum monetary payment should be, but will support and contribute to the further work required in this area. In regards to funding any redress scheme, the Anglican Church acknowledges its responsibility to fund redress for survivors who are found to have suffered abuse in its care. Importantly, a redress scheme must have clear eligibility criteria. It must be clear who is and who isn't eligible to participate in a redress scheme. There should be clear criteria for assessing the connection between the abuse suffered by the survivor and the institution. The Anglican Church acknowledges its responsibility to respond to abuse by its clergy, church workers and volunteers, which occurs in the course of their official responsibilities. The consultation paper suggests a broader catch-all which needs clarification. It would be unreasonable for the Church to be held responsible for abuse perpetrated by individuals in a capacity unrelated to their role or activities in the Church, or for any abuse which happens on church property by a person with no official connection to the Church. The problem with this ambiguous criteria is that it's likely to give rise to arguments over whether an abused person is eligible or not, which will cause them further damage and distress.
Can I just perhaps remind you, if I can, we've passed the 10 minutes.
Oh, sorry. Okay. There's only two final matters. It should be clear on the standard of proof to be applied. A redress scheme must have the capacity to resolve matters before it, even when not all information is available or can be verified. In cases where the perpetrator has died or cannot be identified, we support the determination of whether redress is appropriate on the basis that it is plausible that the abuse took place. Finally, I'll just jump to another principle we think is important, is that the redress scheme should provide resolution for the survivor. The consultation paper asks directly if deeds of release should be required. Deeds of release bring a finality to the process for both the survivor and the institution, and we support them being signed when agreement is reached. However, should new information come to light which would have resulted in a different outcome under the redress scheme if known, a previously signed deed of release should not prohibit a further response.
Thank you, Ms Hunt.
There's a couple of matters that I'd just like to raise with you. Firstly, is in terms of the structural issue which is identified as issue 1, a national scheme and so on, am I right in thinking that you're not thinking in terms of a Commonwealth provided and managed scheme, but rather state-based schemes?
Commissioner, I don't think we have any particular preference. We recognise legal and maybe political difficulties with a Commonwealth scheme where after an outcome that will lead to consistent outcomes, be it Commonwealth, a state-based scheme or an institutional with state-based assistance.
Now, I take it then from that answer that the Anglican Church is able to contemplate a scheme where it joins with government in contributing to and ensuring an effective scheme, but also in working with other institutions separate from government to again achieve a consistent approach through, as it were, a voluntary scheme.
Correct.
Yeah. And that's said without any inhibition at all, I assume, is it? There's no difficulty, whatever might be the institutions who seek to come together.
No difficulty at all.
All right. Secondly, on the standard of proof, I confess that I myself hadn't thought in terms that you've expressed. If the abuser is dead, plausibility, but if alive, balance of probabilities. As you know, there's a big difference between those two standards of proof. And it might be thought that there's an advantage thereby given to someone whose abuser happens to be dead, as against someone whose abuser is alive. Do you think that that would be seen as fair by everyone?
Well, we think it is fair and it's appropriate. We ought not to put survivors through a punishing process where there's no contrary evidence, for example, the abuser's dead or is not connected with the institution or can't be identified. And that's the current process, plausibility, which is used for Anglican schemes. But where the perpetrator is alive, and sometimes they do deny the abuse has happened, fairness requires that that be tested through a disciplinary process, and that's the current model which is used at the moment, that redress will wait until the disciplinary process is complete.
Can you help me? What's the disciplinary process that is undertaken?
Well, the question of the fitness of the member of the clergy or church worker to hold office would be determined, and as part of the question of determining fitness, the particular allegations, did the abuse happen or not, would be determined.
And at the moment, the church then accepts that as, if it's in favour of the abuse having happened, determines the entitlement to redress. Is that the way it operates? Yes,
there would be no issue in terms of the survivor further proving that the abuse happened. That would be an accepted outcome.
And does this process mean that the abuser has to give evidence and be cross-examined and so on?
If it's contested, that would normally be the case, yes.
It's often the case that when a person makes a complaint, they have the opportunity to make a statement and discuss that statement with an independent investigator. So it isn't necessarily an adversarial cross-examination. It's their statement would, the investigator would provide advice on the validity of the statement.
Without there being, as it were, a head-to-head contest?
I don't think you can give a categorical answer to that. Our tribunals, if there is a fully fledged contest on the facts, it may end up involving some cross-examination, but I think those who hear these matters are sensitive to the potential impact on the survivor.
Well, that's the issue that lies behind that, of course, isn't it? When you're approaching a redress payment as opposed to a court, there's a risk that you will deny people who might be entitled because they just don't want to go through that process.
That is true, but there needs to be fairness, and it would be demonstrably unfair if plausibility applied to every case, including where the abuse was denied, because the reputation of the alleged abuser could be irreparably damaged in circumstances where the allegation was never tested. So it is difficult, we do accept that.
Now, I can understand, because it's often said, that a deed of release brings finality. But what's the advantage to either party in finality, in capacity to bring a common law claim being a condition of achieving a redress payment?
We think the advantage, at least from the Church, is that they know, in the absence of extraordinary circumstances, that their commitments will have been finalised. As we see it, the counselling components for the future would have been dealt with through a payment, and any monetary payment will have been already paid. So that's helpful to the Church. I think to have any sort of payment to always be seen as provisional is not going to be helpful for the survivor either. And that's why we accept, in circumstances where a further injury has come to light that wasn't known at the time, that of course it should be capable of being reopened in those circumstances. But where there's full disclosure and the survivor is happy to come to an arrangement, it should be final.
What about the circumstance that it becomes apparent subsequently from documents that might become available, which may not have been available to the survivor, that in fact the Church knew and did nothing about responding to the conduct of the abuser, and thus a common law claim clearly emerges from documentary material that wasn't previously available? Would you contemplate then that the deed would be set aside?
We would like to think that the circumstances in which a deed could be set aside would be broad. You know, in terms of whether it would always encompass circumstances like that, that would be a matter that we'd further investigate. But we're not seeking to close the door irrevocably in circumstances like that.
Might be hard to find a formula of words that meets that objective.
It might be, I agree, but...
the other issue I just wanted to take up is the duty of care issue, which is a difficult one. You know that in England the Supreme Court has moved down a path which imposes liability on institutions in particular circumstances, irrespective of whether the institution was itself negligent. Now, do you have any knowledge of how that's working out in practice in England?
I don't.
Well, Your Honour will be aware of the 2013 decision involving the Catholic Welfare Society. There's been a more recent one of Woodlands in 2014 involving non-delegable duty. In the case in the New South Wales Court of Appeal recently, the High Court refused special leave, and it would have given the High Court an opportunity to look at dual vicarious liability. It seems at the moment the High Court in Australia is...
There's no doubt about that, but I was wondering whether you had any knowledge of how it's worked out in England where the change of the common law has occurred.
I'm not particularly aware, no.
As far as the reversing of the onus of proof is concerned, you may not have been here, but it's clear that there are a number of institutions which accept that that's probably a fairly good idea because of the discipline it would impose on the institution. But the Church, the Anglican Church, doesn't see it as a good idea. Is that right?
We see some difficulties in terms of coherence in the law to reverse the onus for this particular issue, and in other circumstances where there were torts, it would not be reversed. I mean, I guess it could be done, but we find it hard to see that these sorts of injuries would be dealt with differently by the law.
Well, of course, that's changing the onus of proof goes part way down the Supreme Court English path. They didn't have any trouble with it being seen as a response to the particular circumstance of a child entrusted to an institution's care. Do you think the Church should see it as a special case, as it were?
It may be more, if this was prospective, you know, a church would have an opportunity to put its house in order and there may not be such extraordinary difficulties with it. If it was retrospective, it would be very difficult.
There's no doubt about that. But prospectively, would the Church not see an advantage that it would impose greater rigour than might otherwise exist?
We would like to think we don't need the law to ensure we have greater rigour.
Well, that's the hope of all the commissioners too, that human nature being what it is, the law is, of course, commonly used to impose rigour on the behaviour of people in society and institutions.
Well, we've been responding now since 2004 in a system where there hasn't been law, and we've been trying to achieve best practice. I can't see that commitment changing, whether there is a change in the law or not.
No, but you appreciate the Church, your Church is but part of a matrix of institutions which may not all have quite responded in 2004 in the way that your Church has. Do you think we can stand aside from appropriate policies across the range of institutions that care for children?
I think our particular response to the consultation paper was directed to how we saw it affecting our church. We didn't really look more broadly.
And that's time, Your Honour. I have no questions.
She's telling me to stop asking questions.
Politely.
Thank you both very much. And can you thank those behind you who I know have been involved in assisting with the preparation of the submission, and the Commission both thanks you and looks forward to continuing discussions about various issues with the Church. Thank you.
Thank you for your time.